EEOC or hiring a lawyer. When do you need an attorney for job discrimination in Colorado? Do you need an attorney for job discrimination in Colorado, or should you rely on the EEOC to represent your interests? Employees who suffer discrimination on the job in Colorado likely have never had to deal with the EEOC or hire an employment discrimination lawyer in Denver. Learn more about when you may want to talk to an EEOC lawyer and when you do not have to work with the EEOC. Employees in Denver and other parts of Colorado may have alternative procedures and remedies under state anti-discrimination law, and we will touch on that issue as well. However, the primary focus of this post will be the EEOC process and federal employment discrimination remedies. Most job discrimination claims in Colorado must go to the EEOC. If you believe you suffered job discrimination and need an attorney, you need to know that many federal civil rights laws require you to first file a complaint with the EEOC before you can file a federal lawsuit. Most federal employment discrimination laws require you to file a complaint with the EEOC called a charge of discrimination. After filing your charge of discrimination, EEOC investigators will investigate, and you likely will proceed through an informal settlement process. If your complaint does not settle, then you will either have the opportunity to have your case heard by an administrative law judge or file a lawsuit in court. The EEOC investigator may tell you that you do not need to hire an attorney for job discrimination, but that may result in missing options in your employment discrimination or hostile work environment claims. Why you may want to talk to an attorney for job discrimination in Colorado first. The EEOC intake process for complaints is designed to allow workers to report discrimination on the job without an attorney. However, you may want to schedule a consultation or hire an attorney for job discrimination before filing your EEOC complaint. A lawyer can advise you how to proceed through the process and what to include in your complaint. Anything you leave out of an EEOC complaint likely cannot be pursued later, so it is important to present a strong EEOC complaint. Additionally, Colorado has its own state remedies for job discrimination. The Colorado employment law also empowers the Colorado Department of Labor and Employment to receive charges of discrimination. The state agency can investigate and pursue claims of job discrimination. Colorado employment lawyers can advise you whether you should pursue your claims under federal or state law and with which agency to file your charge. When you can go straight to court under federal discrimination law. Most job discrimination laws require you to exhaust your administrative remedies through the EEOC or a state discrimination agency before you can file a lawsuit. The Age Discrimination in Employment Act, ADEA, prohibits discrimination on the basis of age against workers over 40. It requires employees to file a charge of discrimination with the EEOC but does not require the worker to receive a right to sue letter from the EEOC before filing a federal lawsuit. Before deciding not to file a complaint with the EEOC, you should talk to an attorney for job discrimination. If you have potential claims under both statutes and do not file a charge of discrimination and lose on your Equal Pay Act claim, you may not be able to file a claim for the same discriminatory acts under Title VII. A lawyer familiar with the EEOC and anti-discrimination statutes can help you assess the best course of action. When you can opt out of EEOC involvement in your Colorado job discrimination claim. You have the option under anti-discrimination laws to quit the EEOC administrative process and file a private lawsuit if one or more conditions are true. The agency has not responded with a decision within 180 days and no appeal has been filed on the complaint. The EEOC issued a determination and neither employer or employee filed an appeal. The EEOC does not respond to your appeal or the employer's appeal with a determination within 180 days, and you do not agree with the EEOC's conclusion on your appeal. The EEOC may choose not to pursue your charge of discrimination and issue a notice of right to sue to you. If you receive a notice of right to sue from the EEOC, then you should talk to an attorney for job discrimination right away. Waiting to talk to an employment lawyer or filing a lawsuit can be fatal to your discrimination claims. Finding a Denver employment lawyer for job discrimination. Employment lawyers in Denver and other parts of Colorado often have experience working with job discrimination claims under federal and state law. There are many ways to find an employment lawyer to advise you on your claims. Employment discrimination claims are among the more common claims handled by employment law attorneys in Colorado. Research lawyers and schedule a consultation with one or more to discuss your claims and consider representation. Employee rights lawyers in Denver and around Colorado can discuss the issues raised in this post with you along with other important issues to your potential lawsuit.